All right. So we are looking at, can everybody see that? 10 tips and tricks for testifying in a termination trial. Excellent. All right. So this is version 2.0. I originally did this presentation back in 2017, so I've just updated a little bit. Primarily the updates were my intent was to update it to include some information about testifying via Zoom, because that's a lot of how we are doing things now. And then as I was updating it, I realized that a lot of what I would say about testifying with a court reporter live in person is similar to what I would recommend for testifying via Zoom. So there actually aren't that many changes for the version from 2017 to 2022. The PDF document that I sent over is just an example of potential direct examination questions that an attorney general, an assistant attorney general may ask of an advocate or guardian ad litem during a termination trial. So I put that together, glommed together from several versions that I got from AAGs that I work with. So that's just a reference for you. It might help you when you're preparing to testify to take a look at that. We'll go through that if we need to, but otherwise it's just for your reference. Okay. So this is quite literally, we've got 10 tips and tricks for testifying in a termination trial. Most of what I talk about in terms of testifying today is also applicable to testifying in other situations. I just use a termination trial because that's actually probably the one that we most often get called to testify in. So tip number 1, preparation. Talk to the person who issued the subpoena or a witness list. So generally speaking, if you find out that you are testifying in a termination trial or another hearing, it's because you've received either a subpoena or your name has appeared on a witness list. So chances are your program received those documents and then gave you a heads up and let you know. So most likely the party requesting you to testify is going to be the state or the assistant attorney general's office. So my suggestion is, as soon as you receive that subpoena or you show up on a witness list, reach out to the AAG that has issued the subpoena or the witness list. So just find out from them, like logistics of testifying. When are you going to be testifying? When is the hearing set? And then when, like in the flow of the case, are you planning to testify? Are they planning to have you testify? Generally speaking, in my experience, they have the social worker testify first. And then they'll call maybe like the parents, maybe some service providers. And then a lot of times they'll have the court-appointed advocate or the guardian ad litem testify last as part of their case. So just find out from them, do they think you're going to be on the second day? Do you think you're going to be on the afternoon or the first day? Just kind of get some idea of, hey, how do you think this is going to go logistically so I know where to be when? How will you be testifying? Is this going to be an in-person proceeding? Is it going to be by Zoom? We're in Pierce County, we're doing a little bit of both. I was on a docket this morning, a termination docket, where I had some of my guardians ad litem testifying, but we have some trials that are in person. So just getting an idea from them about what they expect. Theme, what's the theme of the department's case? So obviously if it's a termination trial, the department is looking at terminating one or both parents' rights. Generally speaking, the department is going to have some kind of idea of where they're going with it. So it may be an issue of, chemical dependency, and the parents have never been able to get out of chemical dependency. It may be an issue of, parent long-term incarceration. Maybe parents are incarcerated for some long period of time. So just kind of you probably already know kind of what the theme of the case is based on your work that you've done on the case, but just get an idea of kind of where the department is going to go with this in terms of the termination. The outline, does the AAG have an outline of your testimony or a list of questions they intend to ask? Again, that's kind of what that sample is. That's a lot more robust than most of what I get from the AAGs. Some AAGs are super prepared and are like, oh yeah, here, like I'll send it to you right away by email. Some are a little more like flying by the seat of their pants and they're like, no, I don't have anything yet. So talk to your AAG, talk to your program as well. They may have some samples that they've received in the past that they can share with you, just so you get an idea of what exactly you're going to be talking about. Anticipated areas of cross-examination. Does the AAG have an idea of like what the parents are going to cross-examine about? So they know the case pretty well. You probably know the case better than they do, but they know kind of the legal aspects of it. So they can give you some hints about kind of what to expect in terms of cross-examination. Okay, Number 2, review your file. Ideally, you're going to review everything in your file. That's going to be your own notes that you've taken, reports that you've written, assessments that you've reviewed, emails, family time notes, provider reports, UAs, etc. Your entire file. My recommendation, these are all my recommendations, but as you review your file, make an outline or like a cheat sheet for yourself regarding the case. Ideally, this is going to be no more than 3 pages. And you have to be comfortable allowing the judge and the other attorneys to review this outline. So this is something that you may, depending on what your program advises you, you may be able to bring your outline with you to court. But if you do have it, the other attorneys or the judge could ask to see it. So again, it's got to be something that you're comfortable sharing with everybody. Often a timeline is the best way to organize things. We find a lot of times you've been on the case since the beginning, and all of the other people that are involved in the case came in somewhere midstream. So we always, we often like to say that we're the historians of the case. So again, having a timeline is really sometimes pretty helpful because you can show, you can look back at your file and, say, hey, spring of 2019 was when mom stopped visiting, making notes like that for yourself. Prepare your advocate resume. So as an advocate, you have probably done a ton of training, you probably have some experience, you've got some education that's helpful. So just kind of prepare a specific resume for your advocate work. So whatever that kind of looks like in terms of your education or any experience that you've had. And then if you can ask your program to get a list of all the trainings that you've done, if you haven't kept track yourself, that can be helpful as well. Some social workers, this might not be more recent given the turnover that we've seen with social workers, but historically some social workers have maintained their own outlines.
Morgan, I'm sorry.
Yeah, no, go ahead.
Somebody's not muted and it's like crickly or something. And so I'm wondering if everybody could mute.
Yeah, good. Thank you. Yeah, so just double check, make sure you're on mute. Okay, so some, like I said, some social workers historically had an outline that they maintained. I don't know how often that's the case now with the high turnover that we've seen, but talk to the social worker as well. They may be willing to share an outline with you that they may be using to help prepare their testimony as well. Okay, this is like sidebar, but like the most important sidebar of all. The number one thing is when you are testifying, please tell the truth. You will be sworn under oath to tell the truth, and attorneys can handle it if the truth is not great. But if you lie, it's really, really hard for attorneys. So please, if you take nothing else from this presentation today, please, when you are testifying, tell the truth. Mercifully, I have not had to deal with any of my advocates lying on the stand, so please keep it that way. Tell the truth when you're on the stand. Okay. Like I said, most important little sidebar ever right there. Okay, so testifying, talking about testifying in court. So like I said, when I was putting this together originally, it was back in 2017 where everybody with Zoom was not even on anybody's radar. You were testifying in person live with a court reporter. So generally speaking, and then when I was putting it together, I realized the things that I would tell you about working with a court reporter are also the same things that apply when you're doing an electronic record through Zoom. So if you are in person, generally speaking, they will have a court reporter sitting somewhere near you. So they've got the little like stenographer machine and they sit there and type away while you are talking. If it's an electronic record, sometimes they still have a court reporter in the courtroom, depending on the setup. Otherwise, they may be using an electronic system. Ours is called JAVS. They may be using an electronic just recording device to record. Either way, there's a couple of things that you want to do to keep a really clean record for the court reporter or the electronic recording system. Number one is speak loudly, clearly, and slowly. It's not like normal conversation pace. Normal conversation, there's a lot of speed changes back and forth. This is a lot, it needs to be a lot more formal. And you just need to make sure that you are being articulate and that you are being slow speaking enough to where everything that you're saying gets picked up. I'm a very fast talker, especially when I get like amped up about like an argument or something like that. And I cannot tell you how many times I have had a court reporter tell me like, hey, you need to slow down. So I really have to make a conscious effort to do that. So that just a hint, if you generally talk like me, slow down, pace yourself a little bit, okay? Make sure that you give verbal responses. You have to say yes or no. If you say uh-huh or that's really difficult for us to look back and understand exactly what was being said, especially if it's being, a court reporter writing it down. Also, if you nod your head or shake your head, that doesn't get picked up on the record either. Sometimes attorneys will recognize when you start doing that and they'll give you a correction. They'll say, do you mean yes? Oh, yes, yes. And then, but really just try and be on the upfront, make sure that you're giving verbal responses as you're going through your testimony. This is a big one. Don't talk over the person who's asking your questions. Like I said, it's not really a conversation. I mean, it is a conversation, but it's not like normal everyday conversation. You'll be able to anticipate the end of a question before they finish actually speaking it out. But what you really need to do is wait until you're sure they finish their question, kind of wait a half a second, and then give your answer. So that's kind of twofold. With a court reporter, they're recording everything that's being said, and it's impossible for them to get it down if there's more than one person talking at once. It's ultimately when a court reporter is typing it all out, it's like a transcript. They do actually a printed transcript, and it gets really, really messy when there's multiple people talking at once. With Zoom or any sort of electronic recording, the other thing that we run into is sometimes there's technology glitches and there's like little bit of delays and all that kind of stuff. So you really want to make sure that it's also kind of hard to read cues because you're not in the same room. So there's you get a little bit of body language, but it's a little bit harder to read cues when you're on Zoom. So really make sure that the person is done asking the question before you start your answer. And hopefully they will also make sure that you're done with your answer before they start their next question. So like I said, just kind of give it a half a second after you think they're done and then start your answer. It'll just make for a really clean record, which everyone will appreciate. If you hear the word objection in a hearing, just stop talking. Mid-sentence, mid-word, someone says objection, just close your mouth, wait patiently for everyone to work out what's going on. So the judge and the attorneys will have to have a little bit of a conversation. It may be over your head because they're going to be throwing out some specific objections and then explaining them, and the judge may be asking questions, and basically just sit there and wait until someone gives you some direction about how to move forward. So generally speaking, if an objection is sustained, someone will ask you a new question. So that means there was a problem, whatever the problem was with the previous question, and then you'll just move on to a new question. If the objection is overruled, sometimes it's kind of hard to tell, but if everyone kind of just looks at you and waits for you to say something, that means probably go ahead and answer the question. If you aren't sure, ask. Just be like, hey, I'm sorry, can you repeat the question? Or, I don't understand what the court's ruling was on the objection. And then somebody will explain it to you and tell you to either answer the question or we'll be moving on to a new question. So if you don't understand, ask. Everybody knows that you guys have some legal background and legal training, but you're not lawyers, so it's complicated. So hopefully they'll be kind enough to explain to you when you should answer the question or not. Okay, number 4, testifying. So listen to the question that is asked and answer that question. If the attorney needs additional information from you, they will ask a follow-up question. So the example that I give is if an attorney asks you, do you like apple pie? The answer to that question is yes or no. It's not generally speaking, well, yes, but I really prefer blueberry with a specific crumble crust, and et cetera, et cetera, et cetera. Okay. So really listen to the question. If they want more information, they'll ask a follow-up question. Generally speaking, a lot of times the attorneys will ask you a question that's kind of a yes or no question, and then they'll ask a question that gives you an opportunity to give some sort of narrative. So they may ask that question and say, do you like apple pie? And you say yes or no. And then they could say, well, can you explain to me what your favorite type of pie is? And that gives you kind of a little bit of an opportunity to explain a little bit more about, to answer the question. If the truthful answer is that you don't know or you don't remember, those are perfectly acceptable answers. Nobody wants you to guess or speculate if you don't know the answer. So the way that I see this happen a lot of times is, and the AAG may say, well, what was the last time that mom, what was the date of mom's last visit? Well, so, maybe it was like in the spring of last year, but you don't remember the exact date. You can say, I don't remember the exact date, but I know that it occurred in the spring of 2021 or something like that. That's totally okay. They may ask you for clarification, and we'll talk about this a little bit more, but they may ask you to look at some documents to help refresh your memory. But if right on the upfront, you don't know the answer to the question or you don't remember, those are totally okay answers to give the court. If you don't understand a question, please ask to have the question either repeated or rephrased for you. Generally speaking, if you answer the question, we'll assume that you understood it and responded appropriately. So as an attorney, I know I ask horrible questions. They are compound, they are confusing, they don't make a lot of sense. I am not alone in that. So really, if the attorney asks a question and you're just scratching your head, you have no idea what they are asking, please ask them to repeat it or rephrase it. They have to do that for you. Okay, number 5, when you are actually testifying, let's talk about your demeanor on the stand. You'll be nervous. That's kind of goes without saying.
Sorry.
Yeah.
May I ask a question?
Yeah, for sure.
So what is your opinion on the best way to deal with multiple questions in one question?
Yeah, so we call it a compound question. And it's generally when they're asking, they ask more than one thing at once. If you can, within your mind, kind of sort out the different, say that it's a 3-part question, you can say, I'm going to address the first part of your question first, and you can answer that part. And then you can say, I'm going to address the second part of your question. And then maybe I'm going to address the third part of your question. And if you answer the first part and then you maybe get confused and you say, can you remind me what the second part of your question was? And ask them to repeat it again or rephrase it. I think it's sometimes the other attorney will object to it because it's a compound question, but if they don't, I think if you can kind of break it down in your mind, paying attention to the question and then answering the first part, and then again, asking for some clarification, saying, can you remind me what the second part of your question was? And then answer that part. And then can you remind me what the third part of your question was? And then answer that part. So, because it's going to be, you're giving a lot of information. And so it's helpful for you also to break it down that way to make sure that you are answering the question that they're actually seeking.
Which also then augments the tell the truth aspect.
Exactly. Yep. We want to make sure that you understand the question and you're answering that question. We don't want you to get tricked up or confused at all. So whatever you can do to kind of help, make it in your mind so you're truthfully answering the questions, that's absolutely helpful for everybody.
Thank you.
Yeah, no problem. Okay, so testifying on the stand. So your demeanor on the stand. Like I said, you're going to be nervous. That kind of goes without saying. But as I mentioned before, you've probably been on this case longer than anybody else in that courtroom, and you probably know this case better than anybody else in that courtroom. So have some confidence in that as you go in, that you really know this case very, very well. Limit distractions for yourself. So this probably goes both ways if you're in person or by Zoom. For example, I have certain pens that I can't use when I'm in trial because they click and I click them. Just nervous tick, I click the pens. And so I have a very specific set of trial pens that are specific for because it's a detraction for me. So things like that. So making sure that you don't have, when you're on the stand, you don't have tons of things with you, you're really paying attention, focusing on what's going on. If you are going to be testifying by Zoom, this has of course opened up a whole new can of worms for people testifying. Limit distractions for yourself at home as best as you can. Make sure if you've got other people in your house, make sure they know that you're in court and you're on the record. have a place where, you know, you can work quietly with the door shut, to be not distracted by other things going on in your house. I'm honestly surprised that I've not had a small child or a dog come through today as I've been presenting to you. I have a little office, the door's closed, but things happen. So just making sure that you're in a quiet space where you can do your court work of testifying. I know I was talking to Ryan about this earlier, but I was covering a docket this morning on Zoom. And of course, while the docket's going, I'm doing emails and I'm redacting discovery and I'm doing a ton of other stuff on my computer. So trying to really focus on testifying and not doing other things on your devices while you're doing that. It's probably worth talking to your program and seeing if they actually have a space for you at the courthouse or in their office where you can come and do your testimony via Zoom in the office. That's not a bad thing if your program's able to accommodate that. That's for a couple of reasons. One, it's going to make sure that you're in a professional space in terms of background and things like that. It's going to limit, you know, disruptions because they know that you're in there testifying, doing your court work. Internet may be more stable at the courthouse than it would be at your own home, depending on, you know, the weather and what else is going on. So I know at our court, we actually have Zoom rooms, we call them, where we've got setups for people to be on Zoom, but it's actually a private room in the courthouse that people can do that. So that's something worth looking into if you are called to testify via Zoom. That might be an option for you. So again, limit distractions for yourself, both in person and then by Zoom if that's how you are testifying. Remember, you're a professional and you're an officer of the court. Like, you've been tasked with something very specific to do. You've been trained to do this. You've been trained in this role. And have some confidence in the work that you're doing on this particular case. Be confident, be articulate, be straightforward and honest. Try not to be rattled by the attorneys. Generally speaking, like I said, you're probably testifying on behalf of the state. So the AAG has probably called you. So it's probably the parents' attorneys who may be trying to do some rattling to get you tricked up or confused. Just be calm, be confident, really listen to their questions and respond to their questions. At least in Pierce County, our advocates and guardians ad litem don't get really beat up by parents' attorneys. And I think it's because our parents' attorneys know that they don't win any points from the court by beating you up. Our system really likes our advocates and our guardians ad litem and really puts a lot of weight in our recommendations. And so parents' attorneys know that they're just going to lose points if they're beating up the advocates. So we don't really actually run into that too much of a problem, but really pay attention to what the attorneys are saying and try not to be rattled, but just respond politely and professionally to what they ask you. You have to answer the question unless the court instructs you otherwise. So they may ask a question that you think has no relevance whatsoever to anything remotely related to the termination hearing, but you have to answer the question unless the court says otherwise. Example that I've seen is they've asked an advocate about if she had grandchildren. And, you know, right up front, you're thinking that has nothing to do with anything. But actually, in this particular case, they were trying to understand her experience in interacting with children of this specific age. So it was actually relevant because she had experience interacting with her own grandchildren. So unless the court directs you otherwise, you have to answer the question. This is when an objection might be popped in. If it's something that's super objectionable, one of the other attorneys may pop in. Think before you answer the question. Don't just like start talking automatically. It's okay to take a second to gather your thoughts and make sure that you're responding to the question that's actually being asked of you. Okay, number 6, testifying. So exhibits and notes. So this is just a suggestion from what I tell my people. Talk to your own program. You may have your own way of handling this. But my suggestion is that you don't bring your entire file with you on the stand. We actually had this pop up because this subpoena that we received actually says bring your whole file. And my guardian ad litem was saying, what do I do? You told me not to bring my file, but this says to bring it. So again, my suggestion is like have your file maybe with you at the courthouse in your bag, but don't bring it up to the stand with you. Couple of things about this. This is why you've prepared your independent outline, is you've gone through your file and you've pulled out the relevant information in your head and made that outline about what's important. You've recently reviewed your file, so you should know what's in it. If you have your entire file with you, the court or the attorneys will ask to view everything in that file. So I actually had this happen. I had an advocate who was in the middle of a termination trial, brought her file up with her. One of the attorneys said, I would like a copy of everything in that file. I spent many hours that evening copying and redacting everything that was in the file. So if you have that file, the attorneys want to see everything. Again, if you just have an outline, the attorneys will want to see that outline. But again, talk to your program, get some guidance from them about what they recommend. But generally speaking, you've reviewed your file, you know what's in it. There probably isn't anything physically in the file that you will need to rely on when you're testifying. If you do need to refer to your notes or to that outline or timeline that you've put together, you have to ask permission to do so. So the example that I've given is, if they say, hey, the attorney says, when was mom's last visit? And you can say, well, I don't remember the exact date, but I know that it was in the spring of 2021. May I refer to my notes to get an exact date for you? And then the attorney will tell you yes or no. And then you can look back in your timeline and you can say, oh, yep, there it was, May 21st, that was the last time mom visited or something like that. So again, just ask permission. The attorneys may say no. And they may say, no, just spring of 2021 is fine. So if they say no, then don't look at your stuff. If they say yes, go ahead and look at your notes. But again, any of the attorneys or the court can ask to see your notes if you refer to them specifically. If the attorney has a document that they want you to look at, they have to hand it to you. So like I mentioned, not having your entire file with you, but if the attorney wants you to specifically look at, say, like a family time report from last year, you probably have it in your file, but if they want you to specifically look at it, they have a specific exhibit. It's got a little sticker, typically in the bottom corner. It's like a different color and it says exhibit A or B or something like that on it. That's an official exhibit to the court record and it belongs to the court. And the reason that it's labeled with that sticker on it is we want to make sure that everybody's looking at the exact same document. So you may have one in your file, but maybe you made some notes on it. So that's now a different document than the official one in the court file. So if they do actually want you to look at a document, they have to hand it to you and it's one of the official court exhibits. So they'll hand you a document, ask you to look at something specific, you'll review it. And then when you're done with it, you hand it back to the attorney. And then the attorney hands it back to the judge or to the judge's assistant. If you ever walk away with one of those exhibits, the court gets really upset. So just make sure whenever you finish looking at the document, you give it back to the attorney who handed it to you. And that's something officially part of the court record. Okay, tip number 7, testifying. So now we're talking about direct examination. So this is kind of where that outline that I dropped in the chat is going to come in handy. It's, like I said, it's a sample direct examination that I've put together from a couple of different sources. So the direct examination is when the attorney general is going to be asking you questions, if they're the party that called you as a witness, which most of the time that's the case. So most often the questions are going to be some sort of yes or no question. And then, like I said, a follow-up question that gives you some room to give more details or some more specific kind of narrative answer. So general outline of kind of what they're going to talk to you about. They'll probably start with asking some basic information about you. So that is your name, your years as a guardian ad litem or advocate, what kind of training you've done. So the core training, and then, your 12 annual hours. You don't have to have like a specific list, but you can say, I've done training on chemical dependency issues. I've done training on LGBTQ issues. I've done training on how to testify in court, things like that. Your experience, so how many cases you have been on. What are your job duties as a guardian ad litem? And they may ask you questions about guardian ad litem rules. I've seen that happen a couple of times. So that's something to maybe just familiarize yourself with, particularly if you're going into a very contested trial. But also talk to your program before you testify about this specifically. Our program has kind of a little canned sentence that we use when we're asked about what our job duties are. We have a very specific formulaic answer that we like our advocates to give. So your program may have that too. But it's just kind of a summary of what, the court knows what you do, but they have to make the record. So you can let the court know specifically what you do. So after they kind of do some general background information, they'll ask for specifically some experience that you've had with this case. So when were you appointed on this case? What have you done on this case? Who have you talked to? That kind of thing. They'll kind of probably go through more or less a timeline of the case. So when you initially started the case, what kind of things you worked on, and then kind of leading up to this particular point in the case. So some general questions about the case, and this is going to depend specifically on what this case is about. So if it's a chemical dependency case, it may be questions about, parents' involvement in UAs, or, observations, if you made observations of parents being under the influence at visits or something like that. If it's an issue, if it's a case about, for example, medical neglect, they may ask questions about, your understanding of parents' involvement in medical appointments or things of that nature. So the general questions about the case section is going to be specific to whatever the facts of your case are. And then finally, they'll ask you about your recommendations. So I think everyone knows to terminate parental rights, there's some very specific findings that the court has to make. And one of those findings includes that termination of parental rights is in the child's best interest. Well, that's exactly what we're there to testify about. It's about the child's best interest. So they have some very specific questions that they will ask you because they come specifically out of the statute. But questions about, if the child's in a permanent placement, if the continuation of the parent-child relationship will interfere with this child's ability to be adopted into a permanent and stable home. And then is it in the child's best interest to have the parents' rights terminated and things like that. So they'll ask you some very formulaic questions that, again, come out of the statute, but ultimately getting to that final conclusion that, yes, terminating the parents' rights are in the child's best interest. That's typically why, at least in my experience, they have us testify last. Is the last thing that's listed in the statute is what's in the child's best interest. And our testimony generally makes a really great summary of their case. So that's a lot of times why they have us testify last. They have usually the social workers testify first because they kind of give the history of the case. And then the middle section is like providers, and that gives kind of the more nuts and bolts. And then we provide a really good summary usually for the AAG about why termination is in the parent's best interest. I suppose I should mention this. If you don't think that it's in the child's best interest to have the parents' rights terminated, you should let the AAG know that in your initial conversation. I suppose most of this presentation is with the assumption that you agree that terminating the child's rights is in the parent's best interest. If that's not the case, you need to let the AAG know before you get to a trial, probably in that prep conversation that you have with them once you get the subpoena, is let them know. Okay, we're still talking about testifying. So tip number 8, testifying, what does cross-examination look like? So again, this is probably coming from parents' attorneys. Questions will often be a statement preceded by, isn't it true, or were you aware? Questions are typically more yes or no answers than like those long narrative opportunities. So it'll be things like, well, isn't it true that mom actually had clean UAs the entire month of May? Or were you aware that mom got compliance and progress at all of her last, 6 review hearings? That's kind of the cross-examination question, kind of the style of how that goes. Cross-examination is generally supposed to focus on the same subject areas that were addressed in direct examination. So if the AAG doesn't talk about chemical dependency in direct examination, generally the parents' attorneys are not supposed to address it in cross-examination. That's not exactly how it always works, especially in these cases when everyone kind of knows what the issues are throughout the case. We don't really see that as being an objection most of the time. Usually, pretty much in cross-examination, the attorneys can ask almost anything. And most of the time it does directly relate because the AAGs do a pretty good job of covering everything. So the parents' attorneys may try to rile you up, question your credibility, twist your earlier testimony, and make you frustrated. This is not a personal attack on you. Their job is to represent their clients to the best ability that they can. So keep calm, answer the questions that they asked, and try not to get riled up by them. It probably doesn't make you feel any better, but generally when we see a parent's attorney kind of try and attack you, it's because they don't have a lot of substance to work with in their own case. Unfortunately, their client's probably not been engaged, probably not done what they've supposed to. And so what all the attorney really can do is kind of attack the credibility of the people who are pointing out, hey, the parents didn't do what they're supposed to do. So it's, like I said, it's not a personal attack on you. Sometimes that's the only defense that they can raise when their client really hasn't done what they're supposed to do. So again, just keep calm, answer the question. Don't beat yourself up. Try not to get frustrated. Just pay attention and answer the question to the best of your ability. Okay, then kind of your testimony, kind of getting it all wrapped up. There's redirect, recross, and then judges' questions. So we've done, the AAG's done their direct examination, then the parents' attorneys have done their cross-examination, and then it goes back to the AAG to do what's called redirect. So it's when the AAG gets to ask you additional questions after cross-examination, if they have any. Usually it's pretty short, especially for you as an advocate. And then it goes back to the parents' attorneys for recross if they have any other questions. It's also very short process usually. So it kind of honestly ping pongs back and forth like this and gets a little bit shorter in duration each time. With an advocate, I wouldn't expect testimony to go back and forth more than like twice, because usually it's pretty straightforward. Then the judge is allowed to ask questions. This actually doesn't happen in some states. In some states, the court can't ask questions, but in Washington, judges can. And so it really just depends on who your judge is. Sometimes judges are really familiar with dependency and they ask really, really good, like specific questions that maybe no other attorney can ask because it rules of evidence and that kind of thing. Sometimes judges ask questions that are really like basic procedural stuff because they don't have a lot of dependency experience. But really the judge is allowed to just ask, any questions that they have, they can ask the questions. And then sometimes the judge will then say, okay, does that raise any other questions for the attorneys? And then the attorneys can ask questions again if anything else comes up. But generally speaking, the judge is usually, if the judge has questions for you, they're probably the last one that's going to ask you any questions. Okay, we're on to tip number 10, the last tip. So after you finish testifying, you will inevitably spend some time like self-analyzing what you've testified to. And it's like, oh shoot, I shouldn't have said that, or oh my gosh, I forgot to bring this up. Like inevitably you will do that. So what my suggestion is, feel free to do that, but put a timer on it for yourself. So take the amount of time that you were testifying, say you were on the stand for 15 minutes, double it, and that's how long you get to retroactively analyze your testimony. So half an hour, think about what you did, and then you got to move on. Okay. If there was something extremely significant about your testimony that you're concerned about, let the Attorney General know as soon as possible, ideally during a break in the case. As you know, like court usually, at least in Pierce County Court, starts at 9. We take a break about 10:15, and we get back on the record until about noon, and then we start again at 1:30, take an afternoon, etc. So there are some breaks in between stuff. So if there was something that you misspoke about, something that you forgot, let the Attorney General know during a break, because what they can do is they can actually recall you as a witness to give some clarifying testimony. So I had an example. There was a termination trial last week where the guardian ad litem, it was something about the child had been, how long, the attorney asked, how long has the child been agreeable to adoption or something like that. And it turns out when the GAL first met the kid, they didn't want to be adopted, but then now they did. And so the guardian ad litem was concerned that somehow he didn't answer the question correctly and didn't make it clear that initially the child didn't want to be adopted, but then later the child did want to be adopted. So I had him reach out to the AAG and she said, no, she said, I think the way it was, the way it was worded was correct. And so it wasn't a big issue, but that was something that he was concerned about. So again, let the AAG know as if it's something significant. Well, let your program staff know first, and then they'll coordinate with you if you need to let the AAG know, so the AAG can recall you as a witness if that's something that's needed. Ultimately, remember, you're not the one making the decision about terminating a parent's rights. The court is making the decision. You're simply giving the court information and a professional recommendation to help the court make its decision. So these are, this is a serious decision. This is a really weighty, especially if it's contested and the parents are there and it's very involved. It's a very serious topic that we're dealing with, terminating parental rights. But again, you're not the one making this decision. That's entirely on the court. All that you're doing is providing information and that recommendation. The way that I kind of think of it is, the judge can't be out there visiting with all of these families, observing visits, interacting with providers. Judge just can't do that with a number of cases that are involved. So they kind of delegate some of that authority to you, and you report back to the court, hey, here's what's going on. The court takes that information and then ultimately makes a decision. So we're making recommendations, the court is making decisions. It's not something that we need to carry with us in terms of the gravity of the situation. It's a professional role that you're doing. And generally speaking, the court is really appreciative of the work that we do, just because, again, it doesn't have the bandwidth to go and collect the information itself. That's why it relies on us to do that. Oh, there it is right there. Again, remember, you're not making the decision to terminate parental rights, the court is. You're simply providing the court information, professional recommendations, so the court can make an informed decision. And also too, not that this is the end all be all, but there's always, parents always have the opportunity to appeal issues as well. So sometimes, very often we would like this decision to be final to get permanency for the child, but the parents do have other opportunities to continue to pursue this if there are mistakes that are made in the process. So again, if you receive a subpoena, contact your supervisor. Your supervisor will help you prepare. They will help you reach out to the AAG to get an idea of the logistics, what your testimony is going to look like, and then they will do what they can to make sure that you are confident, articulate, and well prepared to testify ultimately in the termination case. That's my contact info, my email and my phone number. You can always bug Ryan too, and he's happy to share my information if you have any questions or anything else. And I will tell you, your programs do regularly reach out to me if they have questions about things as well. So I'm always happy to help any way that I can with any sort of the legal stuff. So that's what I got for you on testifying. What questions do you have about testifying in a termination trial or testifying in general? Like I said, this was mostly geared towards termination trial. Same kind of stuff applies to testifying in any other sort of capacity. If you're nervous, you can just put it in the chat too. You don't have to talk. That's okay too.
Morgan, I have a question.
Yeah.
And I'm going to have to try to think about the phrasing. I'm wondering if you could give us some tips on answering the question. If termination of parental rights is not granted, how does this delay permanency for the child? Do you know that specific question that's within the criteria for termination?
Yep, exactly. Yeah. So I'm pulling up the statute right now here on my other screen here. So basically the court has to find that the exact language I think that we're referring to is, it says continuation of the parent-child relationship clearly diminishes the child's prospect for early integration into a stable and permanent home.
Exactly.
So,
thank you.
Yeah. Yep. So to be adopted, a child has to have their rights. The parents' rights have to be terminated. So a child can't be adopted unless the parents' rights are terminated. So if adoption is the child's permanent plan, then termination has to happen first. So if we're talking about, how to achieve permanency for a child, and if adoption's been identified as and I'm gonna a little asterisk by that, I'm gonna talk about this in a second. But if adoption's been determined as to be what's in this child's best interest, they can't be adopted unless the parents' rights have been terminated. So that's kind of how I would approach the question is, to point out that if we believe that adoption is the best interest of this child and that adoption is the best way for this child to achieve permanence, kind of the prerequisite of that is that the parents' rights have to be terminated. That being said, there was the legislation that came out last year that really, I don't know if I want to use the word prioritize, but it really said, hey, we need to look at guardianships more significantly as kind of an alternative to adoption. So with a guardianship, a parent's rights don't have to be terminated. And so one of the findings that a court actually has to make when doing a termination is that the department has talked to the caregivers about the option of a guardianship. And for some reason, you know, depending on the specific situation, that was the guardianship was determined to not be that adoption was determined to be preferred over guardianship for this particular caregiver. So the example, I mean, the big example that I have seen is like if you have a foster placement, with adoption, they could potentially get adoption support. So they could get some financial support to help care for that child. If it's just a foster placement, they won't qualify for any sort of subsidy for a guardianship because they're not a relative caregiver. So they wouldn't get an R, it's called an RGAP. So a lot of times there's been, especially with like medically fragile kids, who need a lot of additional funding to help provide care for them. A lot of times the only way that a family can continue to care for this child financially is through adoption. They wouldn't be able to care for the child with guardianship. So that's an example of where the court would prefer, or ultimately it could be determined that the caregiver would prefer guardianship or prefer adoption over guardianship, just because that's not something that they wouldn't be able to financially do it as a guardianship. So again, the court just has to find that the department has talked to the caregiver about the option of guardianship, and then for whatever reason, it was determined that was not a viable permanent plan for this particular situation. So Chris has a question in the chat. Can a party to the case motion for the guardian ad litem's notes, work products, text, emails, etc.? So the answer is yes. But they don't have to do a motion for it. They just have to put together what's called a discovery request. And they have to submit that to basically your program, and they say, I would like copies of everything. So for example, I am in the process of working on a discovery request right now that is 16,903 pages. So I am going through, the case is it's from 2015, so it's a 7-year-old case. So I'm going through thousands of pages of emails. I have to do some redactions because it has like the foster parent's email in there, so I have to redact out that. But yes, a party to the case can ask for copies of the guardian ad litem's file at any time throughout the proceeding, not just at a termination trial. It could be at any time that the case is active. They can ask for a copy of that. So it does happen. Yeah, any other legal questions or anything you have, I'm here happy to answer.
Thank you.
Anything else about testifying or in general? Oh, we got a question here. Hang on. Okay, so I'm just going to read what Sarah put in there. A recent settlement conference to sign an adoption agreement and decide on the details of the agreement. The facilitator did ask the caregivers if they would consider guardianship. Caregivers would be able to provide their reasoning around why that would not work and believe strongly in keeping bio parents in the children's lives, as is reflected in the signed agreement. 2 sets of parents always already emailing back and forth and arranging the first meeting. They also asked about guardianships and FTDMs. Yeah, so the department is really taking some active steps per what the legislature has asked about, really making sure that caregivers are, that the options are discussed with caregivers and that they're making informed decisions about what's best for the situation. Whether it's guardianships or adoptions. We've had a couple of issues in our counties where there's been the caregivers have felt some undue pressure on themselves from the department about choosing guardianships over adoptions. So we've kind of been working a little bit on the back end to really make sure that the social workers are, you can't threaten caregivers if they want adoption over guardianship. You're just supposed to be providing them the information so they can make an informed decision about what is preferred for them in this child situation. So we're still working on that, but yeah, you're definitely going to see some more discussions about guardianships because the legislature has said, hey, we need to talk more about this as an option. We have seen the one interesting thing is we've seen I don't know if it's related, but we will certainly see it with more guardianships being entered, but we've seen more requests for termination of guardianships lately. So that's where basically if there's a number of statutory things that the court has to find, but basically we had a case where a parent was fully engaged. Guardianship was entered a couple of years ago. A parent came back, was fully engaged in chemical dependency treatment, had been clean and sober for a period of time, and said, hey, I'm in a position where I've remedied my parental deficiencies. I would like my kids back. The caregiver was a grandmother and she agreed. And so our court did kind of an investigation, and or we were assigned to it. We did a little quick investigation and said, yeah, it's in these kids' best interest to be with parents. So Katie asked, what's the main difference between adoption and guardianship? The big difference is with adoption, parental rights are terminated. With guardianship, they're not. With guardianship, it almost, what comes out of it is almost kind of like a parenting plan where there's like some agreement for how often the kids can see the parents. Of course, we do have set sometimes with an open communication agreement out of an adoption, but usually with a guardianship, it's a little more, there's a little more flexibility with the family kind of working, you know, or the between the guardians and the parents about what that looks like. The other thing too is the guardianship is, like I said, it could be terminated. So with adoption, it's like final and done. With a guardianship, it could technically be overturned, but could be terminated. Yeah, Jen, I see Brett's commentary in there too. Tribes, generally speaking, don't agree to, sorry, screaming child in the background. Tribes generally don't agree to, a lot of times they won't agree to adoption. There's a few tribes that will, but there's some that don't. And a lot of it has to do with that termination of parental rights and terminating the tribal line. That's a big thing that we. Cool. All right. Well, thank you guys so much. Like I said, my materials will be up on the website, Ryan will get that there, and it's got my email and my phone number and all that good stuff in it. So happy to help anytime if you guys have any other questions, but thank you. I hope you guys enjoy the rest of your conference this week and next week.